All right, well, let's get going. This week we are week 2 of Fire 351. And this week we are talking about the super exciting topics of common law and property law. Now, let's start real quick with just a brief synopsis of what you'll hear the word tort law or common law and what that is. Um, Interestingly, there's a what we call the restatement of torts that I'll talk about in a little bit. But basically, common law is all of sort of the civil laws that are out there, or civil justices that you have available to you as an individual. And the whole point of the tort laws or common laws was basically based off of a really old legal system that we brought over to the United States from England. And really what common law is, and the reason we call it that, is because a lot of these cases were decided in the courts of commons. And so what happened over the years was that a suite of laws, if you will, were created around that, those various court cases that were decided, and it kind of created a legacy of information under which we tend to operate. And so while a lot of that has been replaced after the United States was created, we still have a lot of holdovers from that, and that's where these sort of terms of common law come from. Property law is just what it sounds like, property law. That's, again, a lot of imported information from England, but certainly a lot of evolution since the creation of the United States. So let's start again with the basics. Personal injury and torts. Oftentimes when you talk about tort law, you're talking about personal injury. Now, don't think of personal injury just in terms of, sort of the ambulance chaser type law, right? Yeah, there's a lot of that. There's the slip and falls, there's the injuries, that sort of thing. But torts are really this umbrella concept for civil wrongs that are recognized under the law as a grounds for a lawsuit, right? And again, because a lot of this stuff was developed around court cases and decisions made by judges, the idea was that there was so much sort of similarity between these cases and judges. When you do establish something, it is established as a precedent under the law. And so combining all of these things together under what we call the restatement of torts, both the first and second restatements, they are issued by the American Law Institute, and it summarizes the general principles of common law in the United States under tort law. And it talks about all the relief for damages incurred and all sorts of other harms that can occur to folks. And so this restatement is kind of an informal way of grouping all of these court cases and precedents and everything together under a body of laws, right? And so states get the option of adopting this restatement of torts, and you don't have to do it wholesale, right? You don't have to adopt the restatement of torts and agree with 100% of everything that's there. The states can kind of adopt pieces they want to and change things that they don't. And so every state has a slightly different view of tort law. And of course, every state has their own, legal system as well, both at the local level and at the state level. And so those court cases set precedent within those states and help modify our interpretation of tort law. And so it's a very complex field, and it's something that changes quite a bit and can change with your legislature as well. So if they choose to, pass new laws, in their assembly or Senate bills, that will, sort of reshape tort law in the state as well. Now, for the most part, if we're talking about an injury of some kind, and it doesn't have to be a physical harm, we'll talk about what injury means exactly, but this injury, the only kind of remedy you have is redress, right? That's what we call it, redress, in some form of personal property or loss or something. And really what it means is you either get money, you get your stuff back, or there's injunctions that can be applied, right? And what an injunction is it basically stops somebody or a business from doing something that was or is harming you. Okay, so that's kind of what tort law really is. But again, just think of it personal injury law. That's an easy way to think about it. Recovery also can come in the form of all of your lost earnings capacity, pain and suffering, reasonable medical expenses, present and future expected losses, livestock, timber, rangeland, right? There's this whole category of stuff. Basically, what the courts try to do under this suite of laws is try and figure out how to make you whole as much as they possibly can, right? And so they have a lot of different mechanisms to be able to do that. Now, tort law, very specifically, don't get confused here. This is not criminal law. This is one individual or business suing another individual or business, right? So it is a private form of action between two parties. It is not a criminal action under criminal law. This is completely under the civil law standards. And so that means, again, we're not dealing with, under criminal law, you're not dealing with the beyond a reasonable doubt standard. You're dealing with the standard that's referred to as preponderance of evidence, which basically just tips the scales, right? 50 plus 1%, right? So there's all sorts of different types of torts that are out there. There's intentional torts, right? Intentionally hitting a person is a wrong, right? It's a wrong, and an intentional tort is a wrong that the defendant knew or should have known would occur through their actions or their inactions, right? And by inaction, a lot of tort law focuses around personal injury claims. And traffic accidents and things are always great models to talk about when we talk about tort law. So an action of you speeding and causing an auto accident is something that you should have known would occur, or could have caused that. Your inaction is not paying attention to the wheel and being on your cell phone, or not braking or swerving, or other things that could cause an accident or a harm to someone else, right? Now, this is much harder to define, especially when we try and apply tort law to fires or wildfires, and I'll talk a lot more about that. And it's even harder, like, is it intentional? Let's say as a property owner, you have accumulation of fuels, or you manage your property poorly, your house, your deck, your landscaping, whatever it is. Is that an intentional action? Does it fall under that inaction kind of piece? It gets a little fuzzier, but that's okay. We have some other solutions here that we'll talk about. And here they are. One of them is negligence, right? You're causing an accident or a harm to another by failing to obey something like a traffic law, right? Or failing to obey something like your local code that says you have to manage your fuels and defensible space, right? This negligence also occurs when your actions or the defendant's actions were unreasonably safe. So back to land management, how do you apply negligence to land management, right? Were you negligent in how you managed your property, and the way you managed that property caused that fire or contributed to that fire in some way, right? The same can be thought from a utilities perspective. If you're managing all of this infrastructure for, transferring electricity across, the region, could you be found negligent in, causing a fire because of the poor management of that infrastructure or maintenance of that infrastructure, right? And then there's this other thing called strict liability torts, which I'll talk a lot more about as well. Strict liability is oftentimes applied to liability for making or selling certain types of products, certain inherently dangerous products. Firearms are an example of that. There have been a number of cases surrounding things like gym equipment, right? You're lifting a lot of very heavy weight, and you don't want something to break accidentally because of defective product. So if you're selling a product that is inherently unsafe, and if that product breaks, and it's a fault of the manufacturing, the assumption is it's automatically the fault of that company who built that product, right? And strict liability, it doesn't depend on the carefulness of your industry, right? It's just that product, that thing that you're doing, the transportation of hazardous materials, right? The transportation of hazardous waste, or say nuclear waste, that is inherently a dangerous activity. It doesn't matter how careful you are, and it doesn't even matter if the accident that occurred that spills that waste on the freeway was an act of God, a hurricane, a tornado, a meteor. Doesn't matter. You are strictly liable because that activity is so dangerous, right? And so under all of these solutions, when we talk about wildfires, strict liability becomes a very interesting topic, because this is and was the standard. So there are some changes in the legislature that have been happening over the few years. The standard for utility caused fires or related fires in California. And so the idea was, you know, the management of utilities, natural gas, electricity, are so inherently potentially dangerous that any fire that occurs that is a result of that equipment, they're strictly liable for. Now that has been changing over time, but it was sort of an interesting standard, and some states still hold those standards. So when we talk about the evolution of fire law, remember there aren't specific laws for this, so we cut and paste other pieces of the law, like what we have in oops, sorry, hang on a sec. Sorry, I had a little bit of a error with the screens here. So anyway, so what fire law really does is it pieces together all of the different stuff that we have available to us under the law, right? There isn't a specific fire law we can point to, but we piece together property law and tort law and everything else to help manage this. Now, damage due to fires, negligent or otherwise, is older than the law itself. This has been something that we've been dealing with for a long time in society, as long as we've had societies and as long as we've had fires, right? From the very beginning, basically. And so there's a lot of other stuff that goes into this besides just the laws we have available to ourselves, right? A lot of what dictates how we deal with wildfires and fire incidents, even in fires in the home and the spread of fires from one home or a business to another, or to other properties and that resulting damage. Part of it is just based on local norms, right? So historically, before we had fire agencies and insurance companies and municipalities and everything else, you know, a fire would happen, everybody helps put out the fire. Everybody does this because they protect one another. And the assumption is, you know, if I help you put out a fire on your property, you're going to help me if I ever had a fire on my property, right? But eventually that system, you know, starts to break down, and it's not as balanced as it should be. And some people are, you know, more at risk or cause more fires than others. And so you get the government coming in. And remember, government regulation laws, that's just interference in what would otherwise be natural relationships. And so the government comes in with laws and regulations. And then our legislator comes in again with statutory laws that address fire issues and things that they pass in the legislature, either Congress or the Assembly or Senate in California. And then finally, tort law, you know, fills in all of these other gaps, right? And this is what, again, we call common law, and it's created through judges and court cases. So that's kind of the bundle of stuff that we have available to us under fires. So let's say we have a fire. Now what? What happens? Well, you got to ask yourself a whole lot of questions first. What's the cause of the fire? In many cases, the case ends right there for lack of cause, right? So you have the fire investigation trying to figure out, and you know, do you have a clear-cut case of where this fire started or why? And it's not always the case that you're able to figure that out. Now, depending on the cause of that fire, that means you either have a civil or a criminal case, right? And again, this goes to reasonable doubt versus preponderance of evidence when you review that case in court. But again, it depends on what the cause of that fire is. An arson fire is a cause for a criminal action against that individual. But you can also have a civil action, right? So I always like to refer to the O.J. Simpson trial as an example of criminal versus civil. Recall O.J. Simpson, was tried for a murder, and in his criminal case was found to be not guilty because there was reasonable doubt. But they also brought a civil case. The families brought the civil case forward as well, and he was found guilty based on the preponderance of evidence, a different standard, a lower standard. But again, don't forget the criminal case can involve jail time or one's life. Civil case, again, under tort law, those actions of redress that we have available to us include penalties, monetary damages, that sort of thing, right? So again, you have a fire, what was the cause? That helps you figure out what your legal action might be. Now, the next question you have to ask yourself is, can the cause be attributed to an act or an omission? Is it that there's a direct cause? Like I was mowing the lawn and my lawnmower sparked the fire, and is that an act? Was I using that piece of equipment on a high fire risk day, and should I not have been doing that? Right? There's all sorts of questions that we need to ask ourselves if we're going to get into this. So the next question, of course, the next question, of course, that you have to ask yourselves, let me go back here, I apologize, is this question of vicarious liability. Who else can be blamed, right? I may have started that spark for the fire, but there may be a whole other things between me causing that spark and the end result of where that fire ends up and is finally put out. And there may be a whole lot of other stuff in between me and there. So are there other folks that are in some way vicariously liable? Also think about it from the perspective of, if I'm a worker, right, and I'm out there and I'm mowing the lawn or doing whatever I'm told on a day that I'm not supposed to be doing that, but my boss tells me go out and do this anyway. I may be the one that sparked the fire, but that person, that boss, might be vicariously liable because you're just going to follow that chain up of sort of decision making that got us to where that fire occurred, right? Okay, so we figure out the cause, we figure out, it's an act or an omission that caused that fire. Now, the next question is, are you immune from any sort of liability, criminal or civil? Now, the government, and we'll talk about that, and that was really chapter 1 and chapter 2 that I want you to read this week. That's really what that focuses on a lot, is the idea of government immunity from its actions related to fires. It's a tougher question, and it's getting tougher to answer. The answer, I'll tell you, used to be, yeah, they're completely immune, right? And again, the cause of action, that case, that liability, it ends right there if you're immune. Could actions, the next action, if you're not immune from this, then could actions have been taken to prevent that fire, right? Now, this is more problematic. Could actions have been taken to minimize or mitigate the fire? Most likely the answer is yes. But it gets into this weird fuzzy area of the law called the reasonable standard, right? Or the reasonable person standard. How far do you push that? Yes, there's things you could have done to avoid or minimize or mitigate that fire. But how far do you push that? What's a reasonable expectation for someone? The last thing you need to think about is, what is the level of understanding, appreciation, planning, or prevention that should be considered that standard or norm by which to actually compare something like neglect? Like you neglected to do something, you are negligent in some way. And so what's that standard that we compare it to? Again, this is where the law gets pretty fuzzy, and oftentimes you have to. This is why tort law exists, because there's nothing in the law that really sets that standard. And so that standard is set by those prior court cases, and you use those for your analysis to try and establish that level of liability or what the norm should be considered. Now let's talk a bit about causes, right? Cause comes in basically 3 different forms that we're going to care about. There's other types as well, but the 3 forms that we care about the most are what we start with is causation and fact. This is what we call the but-for cause, right? But for me doing this action, that fire would never have started. But for me sort of negligently using incendiary rounds that are illegal in the state of California to fire into some BLM land, that fire would never have happened, right? It's always and we use the but for because that's just kind of the legal terminology. That's the analysis that gets used. So, but for my action, would the harm have occurred, right? And think about it from the perspective of, not just the fire starting, but the stuff that the fire damages. So, but for me being negligent in my action, that house would never have been burned down. That person would never have lost their life, right? That's the but for. It's a direct relationship between those two. Now, there's the next form of cause or causation is joint causation. Two or more causes resulting in the harm. Now, this is difficult to partition this out, right? The person who starts this fire versus the person who poorly managed their property or even has code violations, right? It gets a little bit more challenging to partition responsibility to the various parties, right? But for me going out and doing something on a high fire risk day, like mowing lawns or using heavy equipment when I shouldn't, but for that happening, that fire would never have occurred. However, let's say that fire really spreads because the next door neighbor is illegally storing fireworks, right? And that causes a massive fire to start to spread for there. So now, how do you partition that responsibility at that point, right? That's where it gets a little tricky. And then there's this last type of causation called proximate causation. Now, the but for causation can always go a bit far in your analysis. But for my mother giving birth to me, I never would have been out mowing the lawn that day and causing that fire, right? Obviously, that's a link that goes way too far, right? And so proximate causation kind of tries to address some of that issue of linking responsibility back to an action. Proximate causation is really, it's the legally liable cause is the one closest or most proximate to the injury, right? You can think of it kind of like Occam's razor, right? You've probably heard that expression before. The simplest, answer is usually the right answer, right? Well, this becomes a little bit more complicated because, the situation can arise, especially in strict liability, where you've got incidents that occur like, the management of your utility infrastructure. And now, is it a causation in fact, or is it a proximate cause, right? Based on the management of that utility. And again, this is where legal analysis becomes pretty complex. So again, you have all of this case history to sort through, and all the decisions in the courts that help guide the judge and those attorneys to try and figure out who's actually responsible and why. Now, there's other things that can happen, intervening causes, right? Let's say that I get critically injured. The example here is, A, the defendant critically injures B. As B is wheeled to an ambulance, she's struck by lightning. Now, she would not have been struck by lightning if she had not been injured in the first place and wheeled in that, gurney to the ambulance itself. Clearly, then, A caused B's whole injury on the but-for test, right? So let's say that the injuries for A weren't necessarily life-threatening. It was a wobbler, right? Maybe she lived, maybe she didn't. The lightning definitely killed her. So at that point, is B responsible for the death of A? Right. That's where it gets tricky, and that's why we have these intervening causes. At law, the intervention of a supervening event renders the defendant not liable for the injury caused by the lightning. Right? That's the way the law will interpret that. Yeah, you wouldn't have been in that situation in the first place, but hey, that definitely wasn't my fault, right? The same can be said for cases regarding medical malpractice, right? So you're sent to the hospital because something bad that I did, an auto accident or something else, but then medical malpractice kicks in and the doctor or nurse or whomever does something horribly wrong that results in that person dying on the operating table. Well, look, that was beyond the scope of my, negligence in hitting you in an auto accident, right? So it gets kind of tricky. Of course, any doctor or nurse involved in that action is going to say, well, look, they were likely going to die anyway, and that's where it gets really complicated, right? The effect of the principle can be pretty simply stated. If the new event, whether through human agency or natural causes, does not break the chain of events, right, in the sequence of those events, the original actor is liable for all consequences that flow naturally from that initial circumstance. But if a new act breaks that chain, the liability of the initial actor stops at that point. And that new actor, if human, right, would then be liable from all that flows from their contribution. So you can think of it like, again, that wildfire that I start because I'm an idiot in my backyard doing something I shouldn't be doing, and I start a fire. And then it goes into the backyard of that person who's illegally storing fireworks. Well, I have a really good case to argue that my liability ended right there, right? I may have to pay my neighbor for the loss of those fireworks and all the damage that occurred to their property to that point. But I would, in court, be arguing that that's the extent of my liability, right? If not for you doing that other thing, this fire would never have become what it became, after the fact, right? Okay, so let's talk about some other concepts here in the law. One of those is foresight, right? What is the threshold of probability that the particular harm was likely to occur from the defendant's actions or omissions? So there's a great case from 1866 that's in the text I gave you to read. It's Ryan versus the New York Central Railroad. And in that case, if you really read, they don't give you a whole lot of detail in the chapter, but basically there's a fire that gets started. The important part is that eventually somebody loses their home because of that fire that was started. But their home was so far away from the actual railroad incident itself that the judge says, well, the loss of the home is so far away that you don't get to recover anything, right? Because at that point, it became a much different incident, and that conflagration that occurs after the fact wasn't, it was too remote to place on the shoulders of New York Central Railroad. Now, times have changed though, right? And while we tend to use that as part of our description, our legislators and other court cases have decided, again, looking to the utilities as the example, have decided that that's not always the case, right? That distance, that time and space from the original incident does not always make you immune from all of the fallout that can occur. Now let's talk about other torts that can occur, right? So far we've been talking about direct losses, direct impacts from things like fire. What about nuisance, right? Pollution of air, water, or land. Now, this common law backbone of modern environmental law comes largely from nuisance, right? That idea that you are putting something onto my property or into my purview, right? That I can breathe or is on my land or on my water, that impacts me in some way. Now, there are both public and private forms of nuisance. But now let's think about nuisance in terms of wildfires. Are there causes of action for nuisance under wildfires? Let's just focus for a moment on smoke, right? You have these massive fires outside the Bay Area, but San Francisco then is coated in smoke for days. It is a nuisance, right? And there is a health effect from that. So do you have a cause of action against, whomever started that fire under common law, under nuisance here? It's a good question. Well, there's two types of nuisance that can be attributed to, say, unreasonable interference with yourself, right? There's what we call a private nuisance. It's unreasonable and substantial interference with the use and enjoyment of land, as an example, right? That is a private nuisance. You're impacting my property, my interference with my property and the enjoyment of that land. Now, a couple of things have to be true, though. It either has to be that that nuisance you've created is intentional and unreasonable, or unintentional and otherwise actionable, right? But that's just me as an individual. I can sue. Now, there's this other thing called a public nuisance, and you've probably heard this term as well. This is the unreasonable interference with the interest of the community or the rights of the general public. So I, as an individual, may be impacted by this, but I'm certainly not the only one. Now, I can bring a cause of action myself if I choose to, right? But the cause of action by a public nuisance would require somebody else to bring that action forward. I can be one of the folks that's part of this class, right? This is where we get the idea of what we call a class action lawsuit. So I could be one of those representatives of that class, but I'm not the only one. And so there's, often, you'll see class action lawsuits, or you'll see public nuisance claims brought by public authorities, the attorney general, your district attorney, right? Those actions are going to be brought by that authority. It doesn't have to be, though. There are all sorts of pieces of legislation that allow private citizens to represent the public in that case. So maybe the district attorney doesn't want to bring a case forward, but I will. It's not going to be a criminal case at that point. It's going to be a civil action, because I don't have the authority to bring forward a criminal case. Only the district attorney does. But I'm going to bring my civil action forward. I'm going to bring it forward on behalf of everybody in my community, and I'm going to be one of those representatives that's impacted, right? And we call those citizen suit provisions. It's usually something that's defined in the law that allows me to do that. Now, I typically have to wait for that public authority to decide whether or not they want to bring that cause of action forward, right? Do they want to sue for, or on my behalf? And if they choose not to, then I can go ahead and bring my own cause of action, right? But in that case, it doesn't matter who brings the case forward, right? In that case, you can only abate the nuisance, but you can't recover damages, right? I can't say, well, and you should also pay me $1 million for my pain and suffering or whatever else. It doesn't work like that, right? You can just simply stop that nuisance from occurring. This isn't a great cause of action for wildfires unless you can make the argument that there's going to be a recurrence of those fires. All right, what else do we have at our disposal? We have this idea of trespass. It protects the rights to exclusive possession. It is a non-privileged, knowing physical invasion of land without permission, right? Trespass and nuisance, it's a gray area in things like pollution cases. Airborne particles, is it a nuisance? Is it trespass? What about fires, right? Is it a nuisance? Is it a trespass? You could argue kind of both. It's kind of a gray area. If you're a good attorney and you don't have a great, suite of case law to support you, or statutes to support your case, you're going to bring both causes of action, both a trespass and a nuisance claim forward, right? The limitation of trespass is that the action is done with knowledge that harm can be caused. There's a substantially certain result. It doesn't cover unexpected or accidental harm, right? And then there's negligence. Now, this is the broadest category of tort liability and strict liability. It makes up for all the gaps that we see in trespass law, basically. Negligence means, an unreasonable risk of harm to others, right? You, as an individual, owe a legal duty to me, right? And you've breached that duty. And in some way, that breach has caused a harm, and I have to be able to demonstrate that there's a causal relationship between the breach and the harm. This is often difficult to prove, especially in cases of things like smoke and impacts and other things, right? But that's what negligence basically deals with. Now, I mentioned this idea of strict liability. Strict liability is actually a really old concept, but actually comes from a case in 1882 in upstate New York. And it's a case, Geil v. Swan. Geil was in a hot air balloon in the vicinity of Swan's garden, right? He decides to take this hot air balloon up and loses control, something goes wrong and moves quickly into the garden and starts bumping around and breaking stuff. His body is hanging out of the basket at some point. He called to somebody at work in Swans Field to help him. And there was a crowd of people. Look, it's 1822. You know, hot air balloons are a novelty. They kind of still are today, right? And so there's a group of people that was watching this happen, and this group of people sees him in trouble, and so they enter into Giles' property as I'm sorry, Swan's property as well. The balloon's dragged about 30 feet with him hanging off of it. More than 200 people at some point break into Swan's garden through the fences, and they came onto his premises to help. Now, I get it, everybody wants to help. Do we need 200 people showing up? Probably not. The damage done by Guile with his balloon was about $15 total, but the crowd increases damages to about $90. Now, if you were to put it in today's dollars, that's about $2,000 in losses that occur from this, right? So, of course, Swan says, hey, you have to fix all of this and you have to reimburse me for all my losses and everything else. And Guile says, absolutely not. This was just an accident. I don't have to do anything. This, believe it or not, makes it all the way to the Supreme Court. And this is the first case that we have on what is ultimately known as strict liability. Swan sues Guile in an accident of trespass. Guile contends he was answerable only for the damage that he did, if any at all, not for the damage by the crowd. And so the court said, no, you know what, you're responsible for all of this. And here's why. And they created this 6-part test for strict liability, and this test still exists today. So the 6-part test includes the following. First, whether an activity is abnormally dangerous, right? Is there an existence of a high degree of risk of some harm to person, land, chattels, or chattels is like stuff, right, of others, right? Is the likelihood that the harm that is caused would be great? Is there an inability to eliminate the risk by the exercise of reasonable care? And then the next question is the extent to which the activity is not a matter of common usage. Well, even back then, hot air balloons were not common usage, right? This wasn't a form of regular transportation. The inappropriateness of the activity to the place where it's carried on, and the extent to which its value to the community is outweighed by its dangerous attributes. So this then creates that test for strict liability. And if you meet these standards, then all of a sudden that is strict, you are strictly liable. Now, does strict liability play a role in fires and wildfires? Yes, it does. And again, you know, we talked a little bit about that in the context of utilities, but you run through this list of questions, inappropriateness of the activity to the place where it's carried on. Well, you know, we put the utility lines in a high risk fire area. Is it inappropriate to do that? Obviously, right? But what were our alternatives? You know, and so now that's why you're seeing a lot of change and investment in the way we do utilities, undergrounding lines, insulating them, doing a lot of things that were once not common practices because of the cost, because California and other courts have said, yeah, you're strictly liable, right? So that's the concept here. So strict liability example, toxic torts, right? You know, if let's use Agent Orange or asbestos as the example, right? Based on exposure to some substance that's present that contributes to an unusually high risk to humans. You have to show that you're exposed to this substance, that the substance was released by the defendant. Those products can actually cause the type of harm. Let's say you get cancer. Can that product actually cause that kind of cancer? And did that product that you used, right, or were exposed to, did that actually cause the harm? Because you can get cancer from all sorts of stuff, right? And this is the most difficult to prove when you talk about this. And now I'm going to move from just wildfires to say, you know, cancer risk in general and exposure to a lot of hazardous substances. This is an extremely difficult thing to prove. Now, strict liability in fire, fires in your house, fires on your property. right? There's a very difficult intersection. Are you doing something, if you're storing hazardous materials on your property, you're strictly liable for that. If you're storing fireworks illegally, probably strictly liable for that as well, right? But there is this difficult sort of intersection between negligence, accident, and strict liability that's why you end up in court, right? You have to tease that out as best as possible. So what do you actually need to prove a case? You need to prove an injury in fact, like an injury had actually occurred. You have to prove causation, and you have to be able to demonstrate that the injury is some way redressable. There's something that can be done to try and make you whole in some respect. So what is an injury? It's a harm, personal or public, or a class of people. There are damages, interference, death, dismemberment. Those are the kinds of injuries that we tend to focus on. Now, let's go back to causation. I know we're back to this one, but direct losses or harms can always be easier to deal with, right? Cause and effect, we know that. But when we start getting into things like exposures, occupational exposures and cancer, it becomes a lot harder to deal with. It can be complicated by long latency periods between the exposure and the symptoms of the harm. And you have to be able to prove a couple of things. One is that the thing to which you are exposed to is capable of causing this injury. And then the specific causation, that thing actually caused your injury. Now, we have presumptives in the state of California for our firefighters. Some states do not. But it means that if you're a firefighter for a certain period of time and you end up with a certain type of cancer, it's presumed that that's an occupational cancer, right? It is related to your occupation as a firefighter. However, it's not just a blanket assumption. You still have to prove cause and effect. And that gets really tricky, right? Let's say that you work as a firefighter for 15 years and you're working on some of the worst fires in California's history, and you're exposed to all sorts of toxic, carcinogenic, and hazardous air pollutants during that time. And you end up with cancer. But after 15 years of firefighting, you went to work for American Airlines. And at American Airlines, you were working with some very hazardous and toxic substances, jet fuels and other, solvents and things. And yeah, it got spilled on you. And yeah, maybe you weren't the most careful person. And yeah, you had all these other exposures from that job. And then you end up with a kind of cancer that can come from either source, right? From either type of exposure. That's where this stuff gets very tricky. So when we start talking about these kinds of cases, you can go from worst to best of sort of the kind of evidence that you can bring in to make your case, right? Expert testimony, witnesses, all of that, that's the worst kind of evidence you could possibly have, because you'll get dueling experts, right? And then a judge or a jury has to sit there and say, well, which one's better? Well, they might both be right in some ways, maybe not. That's a tough place to put folks. Remember, judges and even juries are not experts, right? The other kind is in vitro studies on animal tissues, in vivo studies on live animals where you expose them to certain chemicals or hazards. And then there's the epidemiological studies. Now, these are the hardest to get at because you're studying humans, you're studying human disease. It provides the best evidence and it's given more weight by court, but we typically don't have a lot of data there. This is why it's so important when we talk about firefighter health and safety to get those epidemiological studies, to get the longitudinal long-term cancer studies on firefighters, because then those presumptive cases that come up in the future, totally different when you've got that weight of evidence behind it. Because one of the things, if you haven't figured it out by now, is there are all sorts of problems with uncertainty in the sciences, right? Science never says anything with 100% certainty. And then there's statistical significance. Any kind of evidence you bring forward, small sample sizes, environmental noise, all the other background stuff that's occurring, causation certainty, and all the other contributing factors, and being able to apportion risk or causation, this causes all sorts of issues. And the other thing is this idea of redressability. How do you fix this? Well, is the case moot? Meaning, does it have a chance of occurring again, or is the cause of action basically never going to occur? There's ripeness. Are you bringing a case forward too quickly? Can you sue a utility company for lack of management of their infrastructure? No, because that lack of maintenance hasn't caused anything yet. You unfortunately have to wait for a fire to occur. Then there's standing. We talked about this already, but standing has to do with, is this the right defendant, right? Do you have the right party bringing that case forward who actually has legal standing? And then that last question of redressability is there a potential of recurrence? Otherwise, again, it falls under that sort of mootness issue. Now, there's a lot of problems with common law, I'll be honest. This is why the legislatures have to make up all these other laws to help fill in some of these gaps. Individual suits are highly variable and can be very inconsistent. There's a high percentage of the recovery that goes to the attorney, sometimes 40 to 70%. Those that sue early often recover more than those suffering belated damages. So get in and get in fast. But a lot of issues. Public and private law can play a role in complex problems, including fires. We know this, right? But common law and public law, it gets a little weird. Factors in deciding whether liability or regulation rule. It's the amount of information you have available to make your case, the ability for people to pay. The guy who started the 2003 Cedar fire by setting a signal fire or whatever it was to try and find his hunting buddy that he got separated from. How was he supposed to pay for, close to $1 billion in total economic loss in the region, right? The likelihood that the private parties are going to sue, that's another issue. And then just the administrative costs of dealing with all this. There's a lot of issues here. So this helps explain why we don't have comprehensive fire laws today, right? It's this complex that it's really hard writing a single law to deal with fires. Legislators are also open to influence, right? That means when these laws are created and you see folks coming forward to talk about utility companies or gas companies or just any number of reasons why we have wildfires or other fires, they're going to be influenced by lobbyists and special interests and everything else. That this occurs, right? But some risks we assume just simply because of the benefits, right? Like, what about utilities, railroads, firearms, lawnmowers, chains dragging when you're towing a vehicle, right? All of these things will cause fires. But some of these things, we accept as risks, and this is where it gets super complicated. Public input from and these sort of large scale events can change our laws. The fires in Paradise are a great example of that. Just look at the California utilities over the last decade to see how all of this has evolved over time. The other thing I want to talk about is insurance, private versus public. Who pays for a loss, right? This really depends on the circumstances. Often both parties will pay to some extent. Destruction of property by government usually isn't covered by a private policy. The government comes in, destroys your home or your property in fighting that fire. And you read these chapters 1 and 2, and you'll see that government has pretty blanket immunity from a lot of this. But your insurance can include losses that are not compensated by the government because of this, what they call the conflagration rule, right? So the government doesn't always pay. The government is usually immune, but not always. The government has been tied to, and the action that they do in destroying your property or harming it in some way has to be tied to an emergency need or public safety. Access is nearly unlimited when you can make that case. But Congress can prohibit the doing of acts upon private property or privately owned lands if they imperil publicly owned lands, right? So that's how far these concepts will extend. Right? It's not just that the government can enter your property and damage it while trying to fight a fire or address that fire, but they can also tell you what to do on your property if you're next to government resources, right? It's unlikely that the government would be held accountable in most cases for the risks associated with the buildup of fuels on their land, right? Their lack of management of their property usually doesn't mean they're accountable, but that can change. And that's why you see a lot of effort by the federal and state and local governments to deal with those LRAs and FRAs and SRAs. They have different standards and they have different laws and different ways that the courts have dealt with them. So jurisdictions can be held accountable if laws are created to do so. Now, here's one interesting note, I think, that came out of one of the chapters. I think it was chapter 1. The government can't be held liable for adopting defective policies. This is a pretty unsettled area of the law. But if the government decides to manage forests in some way that actually increase fire risks, this has happened, right? If it chooses to do this and it's a failure, they can't be held liable for that failure. Now, what about necessity, right? If you have to enter somebody's property to fight a fire, right? That was a big part of what chapter 1 and 2 kind of addressed. Should public officials be granted immunity for their various acts and omissions in fighting fires? Should public officials be granted immunity for their various acts and omissions in preventing fires, not fighting fires, but preventing fires? If you're not doing that fuels management, if you're not managing that property appropriately, should you be held liable? This is part of the discussion for this week, so definitely log on and take a look. Now, let's get into property law. There's a little bit of tort law mixed in here, but the theories of property, property is an unanswerable question. A lot of courts have said this over the years. It's difficult to define. There's a couple ways of looking at it. There's natural law. It's fundamental justice. It's independent of government. You own that thing and it is yours, right? The other way of looking at property is your rights to property only exist because the government allows it to exist. Depends on your perspective, right? But property law is really a bundle of rights. Again, this isn't often a very clear-cut part of the law. It's limited, it's not absolute. It exists only to the extent that they serve a socially useful justification. You know, ownership of stuff is socially useful. And so we try and protect that through property law, right? And the ability to have personal property. We call chattels, these are tangible property, jewelry, livestock, cars. And then there's intangible things like stocks, bonds, patents, debts, and other contract rights. Now let's pause for a moment and talk about some of the definitions. I wanted to mention here that when you read laws, when you read the Constitution, when you read any of these documents, when you read court cases and the decisions the judges have made, they use very specific, very careful language oftentimes, right? You'll hear words like reasonable care or reasonable person. You'll see in the laws, you'll see in contracts words like shall versus should versus will versus may. These all have very specific definitions. And believe it or not, you know, there's Black's Law's Dictionary, if you're interested in picking one up, that helps you understand some of these legal terms. And oftentimes you'll see in court cases that the justices, even in the Supreme Court, will turn to Webster's dictionary for the definition and say our common understanding of this word is this, right? But words are very carefully used in the law. I just wanted to kind of highlight that real quick. So property rights and fires, there are limitations to this. There's that, again, what the chapters talk about, the doctrine of overruling necessity, right? The exception to trespass, right? Government can enter your property to combat a fire. It's also your police powers, right? Prophylactic measures to prevent fires, fuel management, defensible space, code enforcement. And then there's what I mentioned earlier, the conflagration rule. It denies compensation for official destruction of private property in order to prevent the spread or control a fire. Property is defined as both structures, land, and all holdings therein, timber, livestock, grazing lands, whatever it is. This is not an absolute rule, especially in California, but that rule does exist and you need to be aware of it. Now, typically, the government cannot adversely possess your land. And that concept of adverse possession is a blend of both statutory law and case law, like common law. There's a multi-part test related to this. It kind of depends on your state, but it has to be exclusive possession of this thing. It has to be open and notorious. It has to be continuous. Does that mean that the risk of wildfires allows the government to take your property? Well, no, right? The Fourth Amendment to the Constitution has some certain requirements in there, right? One of those is a search warrant to enter your property if no emergency exists. So if the government wants to enter your property because of a fire risk issue, they have to be able to garner that warrant of sorts to be able to do that. But if that emergency exists, if that fire is ongoing at that time, and they can make a case to enter your property because of that emergency, then all bets are off, right? Even after a fire, for an investigator to enter certain properties, they still may need a warrant. They can't just do it because, you know what, the emergency no longer exists. So, but let me tell you, it's not hard to get these warrants oftentimes. But what about fuels management or other code violations, right? Does the government have that right to just enter your property because of a perceived emergency? It gets a little bit fuzzier there, but generally the answer is no, they can't, right? But they have all sorts of other ways of getting at that information. If your property is visible from a public, road, and they see that you're not managing your property the correct way, then yeah. If your neighbor calls code enforcement and says, well, they're violating, brush management or storing fireworks illegally or something like that, they may knock on your door. You can refuse, but they may just go out and get that warrant to complete their investigation. Property rights are not exclusive. You got to remember this. The government gets to tell you all sorts of stuff about how to deal with your property. They can tell you where to build. They can tell you how to build. They can tell you whether or not you can build at all, if that's allowed. They can even come in and tell you what to build, right? We don't want this kind of architecture in our city. We have put a specific plan in place that tells you exactly what we want our buildings to look like. And you can't build something that doesn't look like that, right? There's a lot of authority the government has under especially local government rights. They can tell you what you can do there, how often, and to what extent, right? So let's say you run a business that, crematoriums, right? Crematoriums do not operate 24 hours a day. They are given a certain window of when they can operate during the day. During the pandemic and during the deepest parts of COVID, the government actually had to lift all of those restrictions on crematoriums. But otherwise, they can tell you what you can do and how often and to what extent, right? And they can tell you how to manage your property, right? We don't want you to have vegetation within 100 feet of your house, and it needs to look like this, right? So let's go back to nuisance real quick. I said it was property law is a bit of a mix here, and we'll include some stuff on torts and common law again. So private nuisance in the context of property law means that there's some unreasonable interference, a substantial interference with the use and enjoyment of my land, right? But there's this other concept in property law called coming to the nuisance. Historically, a lot of the oldest cases on this had to do with pig farms, right? And new homes being built next door. And the pig farm owners would get, harassed by the local government and the courts because it smells. And it's an objectionable thing next to where people live. But the pig farm owners rightly asserted, I think, that they said, well, hang on, we were here first. We've been here for 50 years. Then you come into our backyard and you build a home next to us. Well, you know what? Most states now reject that concept. And even the Supreme Court has as well. And the idea of coming to the nuisance no longer really exists in a lot of cases. There was a very famous case in Los Angeles that had to do with a brick making factory in the city of Los Angeles. Obviously, we don't make homes out of bricks anymore in LA, but back in the day, it was a very dirty business, right? Create a lot of dust and everything else. And the issue really was that it was a heavy polluter, and yet homes and businesses had moved around a brick factory that was once isolated from all of that. And I think it was the California Supreme Court, I'd have to look, basically said, yeah, you're going to have to go out of business. You're going to have to move somewhere else. And it seems unfair, but things change over the time, and that's kind of how we've decided to deal with that. So what about wildfire risk, right? Coming to the nuisance. If you build in a high fire risk area, you know the risk, right? The developer knows the risk, the city knows the risk, the person buying that home or building that home likely knows of that risk. So how does the coming to the nuisance apply in that context? That's a pretty unsettled area of the law. And we haven't seen a lot of cases on that, not yet, but I would imagine that we will. So remedies, injunctions, damages, right? Again, you're diminishing the value of my property in some way by causing this nuisance or whatever on my property. And so I'm able to stop you from doing that, or I can collect money for it as well, right? But again, a public nuisance is an unreasonable interference with the general public, right? Usually a public nuisance is brought by that city government or local government or some government entity. And you have to be a private party to be able to do that. So why do I talk about this? Well, let's talk about it in terms of hazardous substances, right? And landowner liability for hazardous substances and contamination. Persons are strictly liable for the cleanup of hazardous substances. Now, the reason I bring this up, you don't need to know all the details here, but the reason I bring this up is because what happens when your property burns down and everything on that property and everything sitting on that ground is now, according to the EPA and according to anybody else looking at it, a hazardous substance. So how does CERCLA, the waste laws, the Comprehensive Environmental Response Compensation Liability Act, how does that apply to the city of Paradise, right? Now that you have a massive area that is in essence, a hazardous material site, how does all of that, how does that work? Very interesting, very unsettled part of law. Let's go back to trespass for a second. A trespasser is strictly liable, right? Good faith and fault and accident and all of that is irrelevant. You're on my property, you're not supposed to be there. Intent doesn't even matter, except that the trespasser intended to enter the land as a matter of their free choice, not that they intended to trespass. So if you think about trespass in terms of property law, can fire be considered trespass, right? Can the pollution that comes from a fire be considered trespass? Again, not very well settled areas of law. So what are all the controls available to us? When you, again, we're talking about property law now. What are all the things that you can do to tell somebody how to manage their land? Well, there's easements, there's covenants, there's equitable servitudes, all terms you can look up if you're interested. There's zoning, there's eminent domain, there's government taking of your property, right? All of these tools are available to you in some form or another. Now, easements, for instance, it's like a utility easement. You know, they're going to put a water line through your property, and or maybe the city needs to put a road, and they're going to take a bit of your property and put that sidewalk in. There's all sorts of different types. There's conservation easements. You know, you want to build on your property, but the government says no, you have to protect part of it for conservation purposes, right? All kinds of easements that can occur. These can be both voluntary and involuntary. Local government especially has a lot of latitude when it comes to that. Those involuntary occur when the government says, no, we're definitely going to be putting a road here, whether or not you want it, right? They still have to compensate you for that. That's under the Constitution. Your property rights are still protected to some extent, but it's the idea of how much they compensate you and what you think your land is worth versus what fair market value might be, right? These easements will sometimes run with the land, right? Some are irrevocable, and some are even in perpetuity. A conservation easement for protection of habitat can be in perpetuity. A road easement can be irrevocable, right? And then there's other types of easements too, negative easements. You can't block the flow of water. You can't block airflow, view, or sunlight. You can't interfere with adjacent structures or support, right? Do you live in an area that has a homeowners association? Because if so, you have covenants against your property. It's kind of the same thing, right? Covenants, they should sound very familiar to you. It's a promise concerning the use of your land, the benefits and burdens, right? You're going to mow your lawn and make sure that you don't have weeds. There's covenants in your HOA that may address that very issue. And if you don't abide by them, they can take action against you, which includes usually just fining you for not doing what you're supposed to. And ultimately, if you continue to ignore them, they can actually levy those fines against the property and put it on the property once it's sold. They collect first, right? A quick note on contracts laws. We don't talk a lot about contracts laws, but a lot of what we're going to talk has, these connections back to contract laws. You can contract for just about anything you want to, but there's some rules that make these contracts unenforceable, like HOAs, right? You have to follow the intent of the parties. And oftentimes that's difficult because contracts or CC&Rs in an HOA or whatever it is, they're written very poorly by folks that use sloppy language. You have to comply with the statute of frauds, right? You're not doing this to defraud someone. And you can never contract for an illegal act or omission, right? I cannot create a contract with anybody to go kill somebody. That is an illegal contract, right? It can't be unconstitutional or violative of the public policy. And it's not something I could bring in court and say, well, they never followed through on their contract, right? It doesn't work like that. Now, the reason I bring all of this up is because, you know, basically what you have when you buy a piece of property is you have a contract with that property, right? Whether it's CC&Rs or zoning, whether it's easements or even what we call equitable servitudes, right? It's defined, equitable servitude is a promise concerning the use of that land for the benefits and burdens, the original parties to the promise and their successors, and it's enforceable, right? Unlike covenants for CC&Rs, the remedy is usually damages. Servitudes can be enforceable through an injunction. So you're going to promise to manage your land in a very certain way. And think about this again in the terms of you know, wildfire risk. You know, your equitable servitude within your community or within, you know, your jurisdiction may say that you promise, right, that to manage your property and all successors of that property in a certain way to reduce that fire risk. And so your injunction, the thing they can do, a city can come in or Cal Fire, somebody can come in and manage that property for you and say, hey, you are not managing your land for fire risk. We're going to come in, we're going to do it for you, and we're going to give you the bill, right? So the other tool that we have available and the other issue of property law is what, you know, is referred to as zoning. You've heard about this, but a quick fun fact is the land use revolution described in the early 1900s was shown in both the Chicago and New York's fairs back in the day, creating what they referred to as utopian communities, right? The idea is nothing new. People didn't want to be next to pig farms. People didn't want to be next to, you know, metals smelting or timber, processing, right? But formal zone authority didn't fully emerge until the 1900s. And it was really in these communities where the first kind of concepts of zoning began to emerge, right? And the first legal zoning actually was in Los Angeles, created under ordinance in 1908. And it established residential areas and industrial areas. Remember, you know, Los Angeles back in the day had a lot of drilling. I don't know if you realize, if for those of you who are from the LA basin or have been around that area, there was a lot of oil drilling and oil derricks. There's a lot of explosives warehousing, brick manufacturing, slaughterhouses. Los Angeles basin was very different. In fact, most people don't know this is what LA used to look like, right? Los Angeles is a huge area for petroleum. If you just go to La Brea tar pits, you'll know why, right? A lot of petroleum underground. These are all oil derricks, oil wells, all over that Los Angeles area. There are tons of them. But eventually, Los Angeles has to grow, right? And we get a lot of other development. Now, you look at these photographs and you can see houses and other things around all of this. We don't do things like this anymore today. So Los Angeles is growing. Remember I said coming to the nuisance? That was part of the argument. Well, we're not going to stop oil drilling here. We have those rights. We have those mineral rights. We're going to keep exercising them. But as Los Angeles grows up, you can see a lot of the oil wells are still there, even in the older downtown Los Angeles, right? Actually, Los Angeles today has one of the most productive oil fields in the United States. But most of the wells today are hidden inside fake office buildings and different sculptures and arts. And so if you look at the Beverly Center as an example, there's 54 wells there. The Packard Building near Wilshire, 52 wells. Tower of Hope is 165 foot derrick underneath that architectural feature now. The Cardiff Tower, 40 wells operating in that area, right? Believe it or not, this is all still alive and well. If you go on top of the parking garage near the Beverly Center and the mall there, you can actually see a lot of this stuff from on top of the garage. But most of it's hidden from the public view. Most people have no idea, especially folks who are newer to the Los Angeles area, have no idea any of this stuff even exists. Now, not all zoning was good zoning. A lot of early zoning was race-based and segregation-based. Baltimore City Council in 1910 created race-based neighborhoods and government-described segregation. You've heard of redlining and other things. This was a very common practice, and it's something that we still suffer from today. Richmond, Virginia passes similar laws a couple months after this in 1910, overturned ultimately by the Virginia Supreme Court, and they said, you can't do this, right? It was followed by cities in North and South Carolina, New Orleans, Louisville, Oklahoma City, all thinking that this is a solution to segregation. The Supreme Court said all these laws violate that right to contract. That's why I talked about that earlier. You can't contract for something illegally, and the right to alienate property. And of course, can't forget about the 14th Amendment, right? Other things, New York City zoning resolution of 1916, originally built in 1870, one of New York's first skyscrapers, stood only 7 stories tall. It burned down in 1912 in the middle of the winter, and it led to new laws related to public safety and code, right? And it started this idea of zoning in New York at that time as well. In 1916, the new Equitable building is built. On that piece of property. Equitable Life Assurance Society of the United States rebuilds and creates a 40-story building with absolutely no setbacks. Largest office building by floor area, 1.2 million square feet at that time, built on less than 1 acre of land. No sunlight reaches the streets, and all the adjacent buildings are shaded out. This is what they did after that fire, right? They basically took that entire parcel and built one massive structure that took up the entire area. The result of that is New York City rezoning. The first citywide zoning code in the United States stops massive buildings from preventing light and airflow and air from reaching the streets below. It creates height restrictions, it requires setbacks, and it led to the wedding cake design that you see in modern high rises, right? And so the city actually puts together all of the code and descriptions and talks about the new kind of architecture that we should be seeing in New York to allow for that sunlight and allow for, the development of areas, but still protect the integrity of the community below, right? And so that's what we have in New York. And so you see all of those early high rises and things come in. They're designed very intentionally with all of that in mind. Now, at this point, why am I giving you all this history? Because at this point, we're dealing with zoning and code and all of this. This is very important to wildfires, right? And the way we manage our communities today. I will say, however, that, what we've done for wildfires and code is lagging far behind other types of structure fire and, all of the things we're talking about here, right? So there's a lot of work that still has yet to be done. Now, going back to New York, by the 1920s, the U.S. Department of Commerce drafts model zoning and planning ordinances to help facilitate other states in drafting enabling laws, drafting their own codes. At the same time, there's a lawsuit in Ohio that comes forward challenging the local government's authority to create zoning ordinances. It's a very, very famous Supreme Court case that ultimately makes its way all the way there. It's called Euclid v. Ambler Realty. Ambler Realty Company filed against the village of Euclid, Ohio, alleging that local zoning ordinances effectively diminished its property values. The city had zoned an area of land held by Ambler as a residential neighborhood, and Ambler said they're going to lose money because industrial buildings are worth a lot more. The basis of the case was that restricting the use of property violated that 14th Amendment to the US Constitution, right? And it also violated the 4th Amendment and some 5th Amendment protections as well. That's their case, right? And here's sort of, if you look at what their plans were, they wanted to protect this property for industrial use. It's actually a pretty famous site. You can still go there today to look at it. And then by today's standards, it's kind of hard to see unless you zoom in here, but this is the Ambler Realty tract. And you look at what's happened around there over the time. The company that owned this it was about a 68-acre piece of property between Euclid Avenue and the rail line. They had all these plans for industrial development. The Euclid Village Council enacts this zoning code following on New York City's, restrictions. And ultimately, Ambler sues the village of Euclid, claiming a loss of this property. The U.S. Supreme Court rules in favor of Euclid and upheld the constitutionality of zoning laws, right? And this was the first big shot across the bow that said the government has the right to restrict uses based on what they think is in the best interests of the public. And from there on out, local government has had this authority. Now, Ambler claimed this was unconstitutional taking, and it was denied equal protection under that law. The zoning ordinance was upheld, and it meets sort of two essential needs under the test of this court case. First, the zoning extended and improved on nuisance laws that provides advance notice that certain types of uses are incompatible with other types of uses in a certain area. And second, that zoning was a necessary element of municipal planning. We want to keep schools in safe areas. We want to keep housing away from industrial areas, right? And so you can do this based on all of those constitutional protections provided under public health, safety, welfare, and even morals, right? Where do you put the adult bookstores, right? These are all things that are treated under code as we know it today. So let me move on real quick. At some point, you could argue that the government regulates you so heavily that they've basically taken all effective value of the property away from you altogether. Now, that threshold has to be really high. Most times, you know, if the government comes in and regulates your property away from you entirely, it's a clear taking. They have to compensate you for that loss. But, you know, if they allow you some value in that property, you know, the idea there is buyer beware, right? You do not get an absolute right to do whatever you want to on that property. You know, I owned a house near SDSU, city of San Diego, put in all sorts of restrictions while I was living there, and everybody living in the neighborhood was happy about it because it restricted people from building mini dorms where you would take an average house and you would put, you know, 14 college students in it. That was okay. Everybody was okay with that, right? Protecting the integrity of those neighborhoods. Now, definitely was not the highest and best use of that land. Right. I argued that there's, you know, all sorts of things that you could do on your property that would be higher and better uses and make you lots of money on that property, but you can't do everything that you want to on your property. Government cannot, you know, or the government has that ability to completely restrict what you can do in the interest of the public. So the other thing too is your loss of your property doesn't have to be total or complete, right? It means that there's some level of opportunity for you to use it. It may not be what you want to use it for, but if the government reserves you some rights, you know, the Supreme Court largely has held that that's okay. Now, you've heard this term before a lot, eminent domain. Federal, state, and local governments have that inherent power to take property for public use over the owner's objection. But you have to have a legitimate public purpose, right? And that's covered under the Fifth Amendment. Now, that legitimate public purpose, that definition has changed dramatically over the years. It used to mean, you know, putting in highways or infrastructure or other things, and then it extended to things like libraries and schools. Most recently, one of the biggest cases to hit the Supreme Court was in the late 90s, had to do with the taking of private property. It was an area near the coast in Connecticut. The city viewed that land as very valuable for economic development and growth and prosperity of its city, and the owners of all of those various parcels. It was you know, just it was falling apart. It was poorly managed. Didn't have a lot of good businesses running in there, and a lot of things shut down. And so the government said, well, we're going to take it by eminent domain. But they didn't use it for the public purpose. They gave the property to a developer to redevelop as sort of oceanfront, you know, mixed use property. And this goes all the way to the Supreme Court. And the Supreme Court, the case really came down to the idea that, you know, can the government take my property not for a public purpose? Like, they weren't building a library or a highway on it. They were giving it to a private developer to build on. And the Supreme Court said, oh yeah, they can do that. That is absolutely allowable because it still falls under that public purpose of what is in the best interest of the health and welfare and safety and prosperity, really, of that community. And so that one case really extended government's reach. And all they had to do was provide fair market value for that land. And fair market value, if you've ever sold a house, you have that appraisal done, you think it's worth something, and the appraiser comes back and says, nope, it's worth less. You in a government taking, they pay fair market value. Now, you can see fair market value. I can take my house and put it on the market and have it appraised. And I will watch a bidding war happen if I put my house on the market right now, because, people are willing to pay a lot more. And I think the value right now is a lot more. But if the government were to take my property, I would not get what I think the property is worth. So why does all of this stuff matter in the context of wildfires? Well, it does, right? Think about how, whether we're talking about takings or zoning or eminent domain or any of these things that we've talked about under the context of property, how do you use those tools for the public's benefit to make sure that our communities are designed and managed safely to minimize that wildfire risk, right? That's the big question. And again, we've said this before from a science perspective. From a legal perspective, wildfire and urban interface fires are easily a generation behind when it comes to other fire codes and things, right? We are still learning. In fact, we know that most of the fire codes arguably are already out of date as soon as they're passed, into code. We don't know a lot about what we're talking about with regard to science and exposure and the spread of fires, and there's just a lot of guesswork that goes into establishing these codes. We talked about studies with NIST, right, where they looked at the size of the grate that's being used in the eaves and the vents on attics and roofs in homes, and code changes and says, no, you got to shrink the mesh size down to a smaller size to prevent these embers and firebrands from entering your attic and starting your house on fire. And then NIST does this study and says, well, it doesn't do anything. The embers and firebrands just simply burn down to a smaller size and still catch the house on fire, right? And so when you talk about property and property rights, where we build, how we do all of those things, going to be very consequential, and we have a lot of work to do, a lot of catch up, in this space, and it's very important that we do that. Now, speaking of all of that, your assignment for this week. So I talked a little bit. You got to chat a little bit about some of the questions regarding common law in the group discussion this week. But your legislative assignment is up on the website as well. There's, it's important for you to understand legislation, how all of this stuff works. The assignment, basically, I give you a website. It's the California legislators website. I want you to look up AB 1431. Its author is Frazier and others. I want you to list who are the authors, what's the current status of that bill. So you should be able to go into this website, find this bill, and then you can look up its history. And I want you to tell me what the current status of that bill is. And that would be basically the most recent action that you're able to find on that bill. What key issue does this bill address? Kind of summarize that for me in one sentence or so. And then what do you think the key parties are that are affected by this piece of legislation, right? And really, I'm just doing this so that you can get a little bit more familiar and a little bit more comfortable with the use of this website, because it's a very valuable tool, and especially as you start getting more into sort of the policy side of wildfires and urban interface. So I'm going to end there, and thank you all for joining me.